In today's session, we will discuss inherent powers of the code. CPC section 151. Let us go through the introduction of section 151 of Code of Civil Procedure 1908. It provides legislative recognition to the inherent powers of the code. Every court has the inherent power to do real and substantial justice between the parties for the administration of which it alone exists. It was held in Manohar Lal versus Seth Hira Lal AIR 1962. Inherent means vested in or attached to someone as a matter of his right. The Code of Civil Procedure is not exhaustive. Section 151 indicates that the court has an inherent power to make orders as may be necessary to secure the ends of justice or to prevent abuse of the process of the court. The inherent power of a court is vested in the court in the interest of justice, that is, ex debio justitia. These are discretionary powers which come to the rescue during unforeseen situations when no other remedy is available. Court has to exercise its duty to do justice between the parties. The inherent power cannot be exercised by the court arbitrarily. These powers must be exercised in exceptional circumstances. The law relating to inherent powers of the court is mentioned in section 148, 149, and 151 to 153 of the code. Section 148 deals with the enlargement of time. It states that where any period is fixed or granted by the court for the doing of any act prescribed or allowed by this code, the court may, in its discretion from time to time, enlarge such period not exceeding 30 days in total, even though the period originally fixed or granted may have expired. Here, it is worth mentioning that Section 148 has no application when the time has not been fixed or granted by the court itself, or a particular act has not been prescribed or allowed by the code. Enlargement of time cannot be claimed by any party as a matter of right because we can see that the use of may word is there in Section 148. Section 149 deals with the power to make up deficiency of court fees. It states that where the whole or any part of any fee prescribed for any document by the law for the time being in force relating to court fees has not been paid, the court may, in its discretion at any stage, allow the person by whom such fee is payable to pay such court fee, and upon such payment, the document in respect of which fee is payable shall have the same effect as if such fee has been paid in the first instance. Now, there are certain circumstances which are bona fide and which are unintentional, and the court fees is not paid, but still the court is bound to dismiss the case in spite of not in favor of dismissing due to the technicalities of law. Now, to cover up these kind of situations, this provision has been provided in section 149 of CPC. Let us move to section 151, which is a saving clause which states that nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of court. There are two cases which are worth mentioning over here. Debendranath versus Satya Bala Das. The phrase ends of justice was explained. It was held that ends of justice are solemn words and not mere polite expression in juristic methodology, and justice is the pursuit of and end of all law. It was also held that these words do not mean vague and indeterminate notions of justice, but justice according to statutes and laws of the land. Ramchand versus Kanhaiyalal AIR 1966. The inherent power can also be exercised to prevent the abuse of the process of the court. An act of the court shall prejudice no one. Actus curiae nominum robabit. Section 152 deals with the amendment of judgments, decrees, or orders. There are instances when there are clerical or arithmetical mistakes in judgments, decrees, or orders, or errors arising therein from any accidental slip or omission may at any time be corrected by the court either of its own motion or on the application of any of the parties. Section 153 deals with the general power to amend. The court may at any time and on such terms as to costs or otherwise as it may think fit amend any defect or error in any proceeding in a suit, and all necessary amendments shall be made of the purpose of determining the real question or issue raised by or depending on such proceeding. Section 153A deals with the situation where the appellant court dismisses an appeal summarily under Rule 11 of Order 41. Now, here, the power of the court is there to amend under Section 152 the decree or order appealed against, and such power may be exercised by the court which had passed the decree or order in the first instance, notwithstanding that the dismissal of the appeal has the effect of confirming the decree or order as the case may be passed by the court of first instance. Now, a few important case laws which are worth mentioning: Saila Bala Dasi versus Nirmala Sundari Dasi, AIR 1958. It was held that the court can exercise its inherent power to add a party or to transpose parties, or where the appeal is filed against dead persons, to allow the appellant to add legal representatives of the deceased as proper parties. In Martin Byrne Limited versus R.N. Banerjee AIR 1958, the inherent power of the court was used to set aside an order made ex parte and without notice to the parties to be affected thereby. Then, an important case, Chinna Markatian versus Ayavu, the court can exercise its inherent power to restore a suit previously dismissed by it if it thinks that such restoration is necessary in the ends of justice. Mahant Ram Das versus Ganga Das, AIR 1961, the court exercised inherent power to extend time for payment of court fees. Another important case is KK Velusamy versus N. Palanisamy 2011, where the scope of Section 151 CPC is mentioned. Section 151 is not The A clause says Section 151 is not a substantive provision which creates or confers any power or jurisdiction on court. So it is merely a saving clause. It is not a substantive provision. B clause says that as the provision of the code are not exhaustive, Section 151 recognizes and confirms that if the code does not expressly or impliedly cover any particular procedural aspect, the inherent power can be used to deal with such situation or aspect if in case the ends of justice warrant it. C clause says that court has no power to do what is prohibited by law or by the code. Clause D says that the inherent powers of the court being complementary to the powers specifically conferred, a court is free to exercise them for the purposes mentioned in section 151 of the code when the matter is not covered by any specific provision in the code, and the exercise of those powers would not in any way be in conflict with what has been expressly provided in the code or be against the intention of the legislature. E says, while exercising the inherent power, the court will be doubly cautious as there is no legislative guidance to deal with the procedural situation, and the exercise of power depends upon the discretion and wisdom of the court and the facts and circumstances of the case. F says the power under section 151 will have to be used with circumspection and care only where it is absolutely necessary, and when there is no provision in the code governing the matter, and when the bona fide of the applicant cannot be cannot be doubted, and when such exercise is to meet the ends of justice and to prevent the abuse of the process of court.